What are the main common rules that need to be considered for patents is like patents granted in different contracting states for the same invention are independent of each other, and granting a patent in one contracting state does not oblige with the grant on the other contracting state. A patent cannot be refused, and then it is also done or it cannot be terminated in contracting state on the ground that it has been done so in any other aspect. The grant of a patent may not be refused, and a patent may not be invalidated on the ground resulting from domestic law. So a patent a forfeiture of a patent may not be provided for all the uh, the required non-contracting and contracting issue. So marks are nothing but no application for the registration of a mark on the ground that filing, registration or renewal has not been affected in the country of origin. The lapse of the registration of a mark is one contracting state does not affect the validity of registration in the other contracting state, where when a mark has been duly registered in the country of origin, it must on request be accepted for filing and protected in its original form. The registration may be refused in well defined cases where morality or public order deceive the public. So, industrial designs, trade names, indications of coarse and unfair competition, when that must industrial designs are protected in each contracting state, and protection may not be forfeited on the ground that articles incorporating the design are not manufactured in the state. Trademarks are something protection must be granted in order to that each contracting state without the obligation of either filing or registration. Indication of a source, then measures must be taken by each contracting state against indirect or direct use of false indication of the source of the goods, then or the identity of the producer, manufacturer or the trader. The unfair competition is where each contracting state must provide for effective protection. So patent cooperation treaty is where it is created a union, and every state has a PCT is a member of that assembly. So role is to amend the regulations and then fix certain fee, budget, then have biennial program. So this patent cooperation treaty was included in 1970, amended in 1979, and modified in 1984 and 2001. So PCT helps to protect invention in large number of countries by filing an international patent application. Advantages is that applicant has up to 18 months more on the desirability of seeking a protection in foreign countries, to appoint local patent agents in each of the foreign country where it is required to be patented, to prepare the necessary translation and to pay the national fees. On the basis of international search report, the applicant can evaluate reasonable probability of the chances of his invention being patented. On the basis of international preliminary examination report, the probability is given stronger. Amend the international application to put it in order before processing by the design office. So the Berne Convention concluded in 1886 was revisited at Paris in 1896 and Berlin in 1909. So it was completed in 1979, amended, but prior to that, at number of places, the convention was held in order to see that there is protection with, against the artistic works also that contain provision determining the minimum protection to be granted, as well as present provisions available to developing countries. Basic principles is like work originating one of the contracting states must be given the same protection in each of the other states. Such protection must be conditional and also independent of existence of protection in the country of origin. So that is the requirement. So minimum standards for protection is it must include every production in the literacy. It should also have certain permitted reservations. It is exclusive rights of authorization, translate, make, adoption, and arrangement of the work performed in the public, dramatic, musical, recite, communicate, uh, mm, broadcasting works, reproduction in any manner or form. So the duration of for this artistic work is protection until 50th year after the author's death. In case of any anonymous or pseudo works, the term of protection expires 50 years after the work. In case of audiovisual work, is minimum term of protection is 50 years. So TRIPS is where we have found that trade-related aspects of intellectual property agreements were done and protected the IPR in effective in an effective way.